All right. For those who don't know, I am Lorraine Bennick. I am your compliance officer here, and I'm not in the office very often, but this is extremely important that you understand the changes and the differences between the old contract, which is the one that we're currently using, and the new contract that becomes mandatory on the 1st of April. So right now it's available, and we are replacing it in DocuSign, in .lube, in zip forms, in every place that you would normally go to get the contract, and it is voluntary. I've already started seeing it when I'm doing compliance. So I'm telling you, people are already using it, and I'm very excited. If you are using the new one, then you need to use all the updated forms. Meaning if there is a lease, you'll want to do the lease addendum with it. So we'll talk a little bit more about that as we get to it. But these on the right-hand side, this is your current contract you've been using. And if you notice right up at the top, it says 2/12/18. That is the current date of the current contract. However, the one over on the left side says 11/10/2020. As of April 1st, everything must be on the one dated 11/10/2020. So on March 31st, you're negotiating a contract, but you don't get it signed till April 1st. Do you have to rewrite the whole thing on the new contract? The answer is yes, absolutely. So if it was executed on the 31st, I'm good with it. I'm going to let it go. But if it's executed on the 1st or later, it must be on this contract. The old contract becomes obsolete and you cannot use it. Okay. So let's look at what they did change. There are a couple of little things where they only changed the word, and I'm going to skip past those and I'm going to go to the big things. Like number C here, the accessories. They added in security systems that are not fixtures, and controls includes the seller's transferable rights to the software and application used to access and control improvements or accessories, and the hardware used solely to control improvements or accessories. So if you have an app on your phone that controls your Nest thermostat, then you have to relinquish that control. Okay, whether you show them how to get on the app and you set them up an ID and you give them a password and let them into it, however you do that, you have to relinquish control of those devices. Okay, there's actually more about that a little later, but they're letting you know right now these systems that are controlled by apps are going to have to be conveyed as well. Okay, I'm sorry. Okay, we'll talk about the leased devices in a minute, because that's actually the next thing we're going to come to. Number 4 is no longer the license holder disclosure. That has been moved to paragraph 8. Okay. What is here in number 4 is leases. And it says that these are leases that affected the actual property. The first one is a residential lease. The property is subject to one or more residential leases to tenants, and the addendum regarding residential leases is attached to this contract. So if you are selling a home that has a tenant in it, you would have to check this box and attach the new addendum for residential leases. That's what it's telling you. I actually had somebody who reached out to me the other day. They've got a property they're looking at, and it has 3 mobile homes on it that are leased out. And I told them they would have to use this new contract because it's the only time you can use the residential leases addendum. Okay, you can't use it with the old contract. Use the new contract and you're going to cover your person much better. All right. Then there is a fixture lease, and the fixture lease means fixtures on that property that are subject to one or more fixture leases. And it gives you some examples. Solar panels, propane tanks, water softeners, and security systems. Those are the most common that are leased. There is now an addendum for fixture leases. If you have, say, solar panels on the roof, you need to ask your seller, are those owned or are they leases? If they're leased, then you must give the fixture lease. okay? The addendum for fixture leases. And I'm going to show you those at the end of this class, so we'll talk more about those. And then the third check would be leases of natural resources, meaning your oil, your gas, your mineral, water, wind, or other natural resources on the property. We've had an addendum for oil and gas for years. So that one they didn't create a new addendum for, they already had one. If you have that, well, does the seller have a copy of the natural resource leases? Have they given it to the buyer? If they have, check 1. And if they have not, check 2 and say how many days they have to give it. Because it says here, 3 days after the effective date, they have to give it. And the buyer may terminate within X amount of days after the date the buyer receives all the natural resource leases, and the earnest money shall be refunded to the buyer. So after they get it, let's say you put 7 days there. They have 7 days to read through all those leases and make sure that they still want to buy this property. They could terminate on that basis, and the buyer could get their money back, their earnest money back. Any questions about those? All right. Here's something that is very different from our last contract where every single box had to be checked. Every single line had to be filled in. Guess what? You may not have any leases.
One quick question.
Yes.
Is that only pertain to active leases?
Yes. Yeah. So here, we may not have any leases on this property. If we have no leases, there will be no check there. So I'm not going to send it back to you and say, hey, there has to be a check here, because you may not have leases, okay? So you will get them, like, let's say you're the seller's agent, you will get contracts from buyers that have no check there. It's okay. If there's no lease, it's fine. Any questions about that? All right, because our next paragraph is a big change as well. Paragraph 5 used to just be earnest money, and it was about 1 inch long. Now you see it takes up half the page. What they've done is they've combined earnest and option money. So what it says is within 3 days of the effective date, the buyer must deliver to blank, let's say Tradition's title, as the escrow agent, because our escrow agent is always the title company, or it could be a lawyer in some cases, but 9 times out of 10, it's going to be our title company. And then we're going to give their address, X amount of dollars as earnest and X amount of dollars as option fee. So right here, there is no paragraph 23 anymore. It's been combined with the paragraph about earnest. Earnest and option money have been combined. There's more. It should be made payable to the escrow agent and may be separately or combined into a single payment. We do not know yet how the title companies want it. They may only want 1 check to deal with, in which case it would have to be earnest and option money, and you really, really need to pay attention to the amount your buyer's given. If, let's just use round numbers, your earnest money was $1,000 and your option money is $100, that check needs to be for $1,100 to make sure that you're covering both earnest and option. And we're going to see some shorted checks. That's just going to happen. So you really, really need to pay attention to the amount of money they're putting here. If the title company allows you to do separate checks, then you can do that. But I'm envisioning that title companies are going to want just 1 check to deal with. Okay. Now, the buyer shall deliver additional earnest money in the amount of whatever it is to the title company within X amount of days from the effective date if there is additional earnest money. And that doesn't always apply. If the last day to deliver the earnest money, option fee, or additional earnest money is a Saturday, Sunday, or legal holiday, the time to deliver the earnest money and option fee or the additional money is extended until the end of the next day that is not a Saturday, Sunday, or legal holiday. Now, this is a change for us because it used to be that option money, you had to deliver physical days. You know, if you executed on Friday, you better have it there by Sunday or Monday, okay? But that's no longer the case. Now, it goes to the title company, so it falls under the same rules the earnest money does. If you were supposed to deliver it by Saturday, well, now you have Sunday and you have to deliver by Monday. But Monday is a holiday, so now you have to deliver by Tuesday, both earnest and option. So that's a change for us. We no longer have to hunt down the seller or the seller's agent in order to give option money. It all goes to the title, and we no longer have to worry about different dates for those 2 checks. It can all be 1 check, all one place, everything done in one time. The amount received shall first be applied to the option fee and then to the earnest money. That's a big change too. I've got 1 check, I'm the title company. I take and I apply $100 to the option money first every time. Remember in my example of $1,000 earnest and 1,000 option, they write a check, it should be 1,100, but it's only 1,000. So what is the title company going to do? They're going to apply 100 to the option fee first. And now we only have 900 left for earnest money. And what happens when our earnest money is short?
We don't have a contract.
Oh, we do have a contract. We always have a contract. They've signed it, they've executed, it's a contract. But what has happened here? There you go. Because the next thing, of course, down here is going to be the failure to deliver earnest money under line C. If the buyer fails to deliver the earnest money within the time required, guess what happens? The seller can terminate. It's specifically called out right here. The seller can terminate the contract or exercise their remedies under paragraph 15 or both. Okay? So let's go back up. The buyer, that's one of the reasons I'm really harping on make sure it's the right amount of money, because it specifically calls out if it's short, then they don't deliver on time, the seller can terminate this contract. And that's what we're going to see happen if you're short. So please check your amounts. But let's go to paragraph A4. The buyer authorizes the escrow agent to release and deliver the option fee to the seller at any time without further notice or consent from the buyer, and releases the escrow agent from liability for delivery of the option fee to the seller. The option fee will be credited at the sales price at closing. Okay? We used to be able to choose, are we going to credit this or are we not? You no longer get that choice. It will be credited, period. Okay? But the other thing is that once that money is received by the title company, it's up to them when they deliver it to the seller. Now, just thinking on the basis of business, if I were a title company, I probably would not deliver that money until I know the funds are good. So that'd be 10 days. Okay, that's probably your option period. They're probably going to hold it that long, and maybe then they cut the check to the seller, or all the way to the end so they make sure it doesn't fall out and they're out that money.
Do they have to deliver it before closing?
They're just, it's up to the title company. So until it actually happens, we don't really know how title companies are going to handle this. But I would say from a business perspective, I want to make sure those funds are good, and I want to make sure that this transaction doesn't fall out.
But is it automatic? You're saying right now we have the choice of saying the option fee will or will not be refunded at closing, but now it will be, period.
Yes. If on our contract in paragraph 23.
Okay, if we bust out, we're still going to let you have our option fee. And we give you a $5,000 option fee, we really want that.
I'm sorry, I missed something. Say that again.
So currently in this market, I mean, I've had buyers or sellers, or not sellers, but buyers put in the contract that it's a $5,000 option fee, and they check it off, it will not be refunded. So it's just a way of giving that seller more money so that they can take that contract.
Right.
So now we're not going to have that option, I guess, is what I'm just clarifying.
In paragraph 23 of the current contract, it says the option fee will or will not be credited to the sales price.
Right, correct.
That's what I'm talking about. You no longer have that choice.
Okay, that's what I was thinking.
Okay.
Make sure I understand.
Yeah.
Okay.
So if we earn money, not refunded.
Yes.
So if we earn money, not refunded.
Yeah.
So
This is going to be interesting.
it,
I think we're going to have to start requiring buyers to deliver earnest money option and cashier's check. That's probably the only way title companies are going to feel comfortable about it.
that could be true. That could be true, or they may start saying, we're not going to do it until right before close, and then we'll send you that. It's really going to be up to the title companies. Yes.
Several of the title companies, and many of them are now using Locam,
Mm-hmm.
which is really, really nice. That is perfect.
Yeah, but even though they're taking funds electronically and they know that fund is good, I don't think they're going to release them right away because transactions fall out and they know that. So I think it's going to be toward the end of the transaction or even at the closing statement. Yes. I think that's where they just credit it, and that's how the seller's going to get it. It would be. It really would. And it would eliminate that money going back and forth if they did it that way. So I'm really interested to see how they handle that. Okay, let's move on. The termination option. For a nominal consideration, the receipt of which the seller acknowledges the buyer's agreement to pay the option fee within the time required, the seller grants the buyer the unrestricted right to terminate this contract within so many days. And that's where you would now put your 10 days, 7 days, whatever it is that you standard use for your option period. And of course, they left in the 5 p.m. You've got to let them know by 5 p.m. This is not a end of day thing. It's 5 p.m. with the option fees. So that stayed. Then we talked about the failure to timely deliver the earnest money. The seller can terminate the contract, but there's also failure to deliver the option money. I don't know how you failed to deliver the option money. If you delivered money at all, it went to option first. So I would have to assume you delivered nothing in order to fail to deliver the option money, or there is no option money in the paragraph A. Okay. And so if there is no option money or it was failed to be delivered, the buyer shall not have the unrestricted right to terminate this contract under paragraph 5. Okay. And then it reiterates that time is of the essence here. So all of your paragraph 23 and all of your paragraph, it used to be 5, have been added together. Any questions about that? I have a lot of questions about it, but until we see it in action, I can't tell you which way we're going to jump. So let's go to the next thing that they changed. They really didn't change anything on most pages, just the date. But when we got down here to what used to be paragraph 4, we now see that it's in paragraph 8. And there are a couple of things that they changed here. It didn't change, you have to disclose if it's your parent, your child, if you own 10% of the business, or if it's a trust in any of those people. That didn't change at all. They just moved where it is. What they did change is paragraph B. All obligations of the parties for payment of broker's fees are contained in separate written agreements. They just moved that here and made it a B instead of a separate paragraph. Okay? There is more about that later in the contract. We'll get to it. So let's go on down to possession. There was an A. When you're looking at these possessions, I'm sorry, that's why it looks funny, because I'm not there. Sorry about that. Where is after closing? There we go. Possession, there was an A and B, and we've now added a C. B was shortened to basically say, after the effective date, the seller may not convey an interest in the property without the buyer's consent. Why? Because all of that verbiage about the leases was moved up to the very first page where we talked about leases. So all of that has been taken out here. All the lease information is on the first page. This is now changed to, you can't go convey any part of the property at all without the buyer's consent. So you can't go start a new lease or lease a corner of your property or put a cell tower on it or anything else without their consent. And then they added in paragraph C, which is smart devices, which is any device that connects to the internet to enable remote use, monitoring, or management of the property, items identified in the non-realty item addendum, or items in the fixture lease assigned to the buyer. At the time seller delivers possession of this property to the buyer, they shall deliver written information containing all access codes, usernames, passwords, and application the buyer will need to access, operate, manage, and control the smart device, and terminate and remove all access and connections to the improvements and accessories from any of the seller's personal devices, including but not limited to phones and computers. Really, what you have to do now is make sure you're having a conversation with your sellers that they're taking it off their tablet, off their 3 computers, off their 3 iPhones, off their Android their son has, every single device. And we forget because, oh, here's my phone, I'll take it off of that. But you also had it on every computer in the house. So we're going to need to remind our sellers to make sure that they're taking it off every device in order to comply with this paragraph. Now, the paragraph before where it says we're going to give written instructions with all access codes, usernames, passwords, and applications. The very first time I taught this class, people threw up their hands and totally balked. I'm not giving my password. I'm not giving my username. Yes, I understand that. So what do? You get them onto that application. You help them set up their username, their password, and then you change yours. Because the house that you're in now has a Nest thermostat, and the house you're going to has a Nest thermostat. You're going to need the same application, but you're going to need to relinquish control of this one and put it on that one, okay? And I think that's what they're really meaning to convey. The way it's written, I would have to say, here's my username, here's my password, you can have it. How could I use it at the next house? Okay, so what I'm telling you is you need to make sure that they understand. They need to give written instructions to them how they're going to be able to use that function and that smart device, okay? It would not be a bad idea to write up instructions so that you can just hand them out and then they can give them. All right, other changes. Down here in paragraph 18, escrow. Escrow agents may require any disbursement made in connection with this contract to be conditioned on the escrow agent's collection of good funds acceptable to the escrow agent. This is covering our title companies when there's a bad check. It's been a policy for years, but it's never been in our contract. Now it's there. And then under expenses, they added escrow agent may deduct authorized expenses from the earnest money payable to the party. Agent may deduct, payable to the party. Authorized expenses means expenses incurred by the escrow agent on the behalf of the party entitled to the earnest money that were authorized by the contract for the party. What are they talking about? Let me tell you what happens. Absolutely. I pre-open title because it's an estate, all right? That costs the title company to do that. And sometimes we don't even realize, but we're asking them to spend money. So whenever you open a contract, they have to do a title search. They have to hire a title abstractor. They have to go out to the county clerk's office. They have to do their due diligence, investigate all of the times the title is transferred, every lien against the property, everything, and come back with the report to the title company. Then the title company pays them. But this transaction hasn't closed yet. The title company has received no money for this transaction, but they just paid a title abstractor. Now the contract falls out. What do? We return your earnest money, but the title company is still out that money they spent on the seller's behalf. So before they release that title company, or on the buyer's behalf, before they release that earnest money, they are going to take what they've spent and they are just due. Okay?
So they're gonna take the buyer.
It depends. If the buyer ordered the title abstract, then the buyer is going to have to pay for that. You see what I'm saying? I don't know which side it's going to come from or how they balance that out.
Yeah, but like if it busts out,
Mm-hmm.
that doesn't mean it's not gonna sell again, so that work is not gonna be for naught. I mean,
That's true. They could charge
it's
the,
not fair to charge to the buyer.
They could charge the seller for that if the money were going to the seller. So it really is going to be, what is the title company going to do here? It's just a right that they've given them to get their money back.
Responsibility to order the survey, and they bust out, and the earnest money goes to the seller, are they gonna take that $20 earnest money?
No, because it specifically says from whoever authorized it, the party that authorized it.
Exactly.
So if the seller ordered that title abstract, the buyer's not going to end up paying for that. The seller's going to be able to use it for up to 30 days. They're good for 30 days.
So the seller typically, if the seller is paying the title, and the seller is typically paying for all that stuff.
Yes,
Except in the case where there's a survey or something
Right.
unusual.
if the buyer's ordered a brand new survey, guess what? He just bought a brand new survey. So that's how that's going to work out. Which party was it that ordered this? If that party is getting the money, then we're going to take it from there. Okay? So they're going to be able to get some of that money back. But you're right, they can reuse a title abstract for 30 days. After the 30 days, it's not good. Yes, if it's the same title company. But if I've already opened title there, I really try to help the title company out and get the title there. Okay. All right. I want to show you paragraph 21. We joined the 20th century anyway. We still have a line there where you could write the snail mail address, but they made it smaller. So yay, go track. I know, email, fax, and everybody's like, what's a fax? But you'll notice they added 2 lines of email. Trek really believes that what should be there is your client's information. They've finally come to understand that some of us realtors have thrown our hands up and said, but when we put our client information, all of a sudden people start talking behind realtors' backs. And that's not a good thing. Or one side starts hassling the other side. And I've seen that happen too. So they said the best thing to do is to put the client's email address and the agent's email address. So they gave us 2 lines now of email. My thought on this is one thing. If my client really, really doesn't want their email available to the buyer, then I might suggest to them that you can have as many Google accounts as you would like. Go create a Google Mail, Gmail, just for this transaction or just for selling your house. And then after it's sold, you can never check it again if that's your preference. Okay? But that will eliminate that, because I've had people say, I don't want my personal email out there. I don't want my business email out there. Fine. Set up an account just for this, and that's the email we'll use. Okay? Yes.
That would be a good suggestion for the smart devices. They can change over their account to whatever the
There.
email for that house and pass it over to them with a 123 password, whatever,
Yes.
and then let them.
That's an awesome way to do it. Yeah. You can do that too. Mhm.
I always just put Terra in.
Yes, you can do that. Trek is now saying, after much debate and much arguing on our part, that both is acceptable to them. That's what they really want to see.
Is it okay with you if we just put our name?
I am, yes.
Because at one point we were encouraged to put the buyer's name.
Mhm. The only thing that Trek came back and said is, wouldn't that make you somehow liable? Okay, as the realtor. And in this rare situation, it might. If you got the notice and they didn't get the notice and the termination period ended before they got the notice, Trek could hold you liable. That,
What about just the opposite? What if the buyer got notice? I mean, the seller, let's say we sent it to the seller didn't tell the agent. I mean,
but the seller got notice. And that's what this says, that you notify the seller at this place. And the seller got notice. So even if his agent didn't get notice, too bad, so sad. The seller got notice and you have proof. Okay? So if theirs is there, but that's why I like both. And that's, when I was talking to the direct lawyer, they finally said, yeah, okay, both make sense. And we do things digitally now. We don't go to people's houses and hand them a termination notice. It just doesn't happen. So we're still dragging them to the modern century. One day we'll get there. But there does have to be something there. And that is the most common reason I kick back contracts, is because there's nothing there. And let me address the other side of this, because I get this every now and then from an agent who says, why did you kick it back to me? It's the seller's agent who didn't write that there. Well, if the seller's agent didn't put a price, would I kick it back to you? Yes. Our contracts must be complete. I will kick them back when they're not. Whether it's the seller's agent or the buyer's agent who didn't fill it in, it's not my problem. It's not complete. Go harass them. Okay. On 22, we've now added 2 more addenda. The addenda for residential leases and the addendum regarding fixture leases. So we're going to talk about those in just a moment. You'll notice here that in my copy, it shows all the stuff we took out. That's all the red stuff. Paragraph 23 has now changed to the attorney paragraph. Okay. The other change they made really applies to teams. Trek has become very frustrated with us putting team names and not actual agent names. They want to know which associate is actually working with the client. So we now have an associate line like we've always had, but they added the team line. That's where you're going to put the team name. So they know which associate is working with the client and what team they're on. Okay? Then down at the bottom, it says pursuant to a previous separate agreement, such as an MLS offer of compensation or other agreement between brokers, the listing broker has agreed to pay the other broker a fee of X amount. This disclosure is for informational purposes and does not change the previous agreement between brokers to pay or share a commission. Trek's been on this little paragraph for years because they keep telling people you can't change what was offered in MLS on a contract because you're not a party to this contract. So you can't do it here. All agreements between brokers are on different documents. In our case, it's the MLS. We offer 3%, we pay 3%. You can't come in here and write 7 and then tell me, well, in the contract, you agreed to pay me 7%. Doesn't work that way because we're not party to this contract. Okay? So they spelled it out. There's no mistake. You cannot change it here. So that shouldn't be an issue anymore. Yes. Uh-huh. Yes, you cannot change it on the contract because you're not a party to the contract. You can change it on MLS. That's perfectly fine. Yes. Have her do that and print it out as soon as it's changed, and there's your proof. Okay. All right. On this, they've changed it all to escrow agent because the title company is going to receipt all the monies now. So that was the only change there. Are there any questions? Okay, I'm going to stop sharing. I'm sorry, April 1st. It becomes mandatory April 1st. I've already asked for it in DocuSign. I've zip forms. They said that it will be in there by March 21st, I think is the date they gave. So it'll be in there by not next week, but the week after. So you'll start seeing it everywhere. You know, I know that people are already using it, so I would think that it's either DocuSign or .loop that's already been updated. I need to go check and see. Dot loop has it already, yeah.
This one, yeah.
No, zip forms is saying the 21st or 22nd. So, let me pull up the two addenda. Wow, it's already there. Awesome. Okay. I went to it last week, so maybe it just remembered. Okay, this is our addendum for residential leases. And basically it says the seller can't execute any new leases or amend the lease that's in place without the buyer's written consent. So even if there is a lease there, you can't make any changes to it at all without asking the buyer. First, all residential leases must be terminated by closing. There's an issue there because leases are legal documents too. And you can't just say, hey, I want you out because I want to move into this house, so I'm terminating your lease. So if there is a tenant in there and they are under a current lease, you might want to have your buyer consult a real estate attorney before moving ahead and saying that. I wouldn't check that without checking with an attorney first. Okay. Now, if they're on month to month, that's a different issue, but you have to give 30 days notice even on month to month. So if you're going to give that 30-day notice, you might want to set your closing date after that 30 days so that you can comply with the 30-day notice. Okay. So just be aware of that. Leases have consequences too. So if they check that one, it actually does say this paragraph does not amend or terminate any existing leases, consult an attorney, or refer to the residential lease for rights to terminate before agreeing to this provision. So they actually did say the same thing I was thinking. You need to consult an attorney before doing that. If there is a lease in place, then number one, deliver of the residential lease. The buyer has received a copy or the buyer has not, and the seller shall provide it within X amount of days. If the seller already knows he has a lease, have them ready. Have him already have sent it to you so that when you execute a contract, you immediately send those leases. I wouldn't post them on MLS for privacy reasons, but I would have them ready to go out to the buyer's agent after you've executed the contract so that you can fulfill that provision. At closing, the seller shall transfer security deposits, if any, to the buyer. At closing, the buyer shall deliver to the tenant a signed statement acknowledging the buyer has acquired the property and is responsible for the return of security deposits and specifying the exact amount. So if you have the buyer and they have a tenant in the property they're about to buy, you need to let them know. Okay, now you have the leases, which also include the property condition form, the lease, and the, seems like there was one other thing. Oh, any amendments that have been done to that particular lease. So all those things are rolled up into the words, the residential lease. Okay, so now the buyer has all of that. We're about to go to closing. I need to write a statement that says, I have the lease, I have the amendments, I have the security amount, a deposit, and this is what it is. And I'm now responsible for giving it back to you after this lease is complete. Okay, because he has to notify. And then it calls out exceptions as described below and to the seller's knowledge for each lease. That the lease is in full force and effect, that no tenant is in default or violation, that no tenant has prepaid any rent, no tenant is entitled to offset against rent, no outstanding tenant claims against the seller, no pending disputes with any prior tenants or this tenant, and no other agreements or options or rights outside of the lease. And if there are, explain it now. Okay? The lease needs to be in good standing. And if it's not in good standing, it calls out, you need to explain. Attach additional sheets if you need to. Okay? And then the seller will promptly notify the buyer if the seller learns any of these statements become untrue. So if the tenant finds out you're selling the property and decides, I'm I'm not paying rent anymore. That becomes untrue, doesn't it? Because it says they're not in default or they're not behind on their rent. So now they are. I need to notify the buyer, hey, the tenant decided he's not going to pay during this contract period. So then the buyer gets to decide what he's going to do about that. Okay. He has a 7-day period. As his sole remedy, he can terminate the contract. Okay. Can't do anything else. He can terminate the contract if he's not happy about it. Any questions about the new residential lease? Yes.
So, in regards to, bond pay, termination of the residential lease,
Yes.
if you've got it, if you're paying, terminate the leases that you have no means to guarantee that the tenant's gonna be removed from the property by close of business.
That falls under landlord tenant law. And first I would look at the landlord tenant guide put out by TAMU, and then I would call a real estate attorney and ask him. Because that's a totally different set of rules. Okay. So there is a great publication by the Texas A&M University's Real Estate Center. There's a big long name. That's a landlord tenant guide. And I would give it to every landlord that I'm working with and every tenant.
As well.
Absolutely. I give a copy to everyone. And it's just a good thing to review about once a year, and just read through again, because landlord tenant law is a whole different ballgame. Okay. It is the landlord and tenant guide.
Might need to handle it. Look for publication, I need to.
Hang on. I might have it right here. Because I usually do, whoops. Okay, it says assets.recenter.tamu.edu. And it's the landlord and tenant guide special report number 866 is what it looks like. Assets with an S dot recenter dot tamu dot edu. And I just keep it up on my phone because people ask me about leases all the time. So it's just one of those web pages that's always open.
And you gotta trust me with kind of formal announcements or publications regarding
Not yet. I've been watching their articles, and they've had multiple articles about the number of people who are behind or who are in forbearance, but they haven't said anything about what they're going to do when that all closes.
Because I was looking at the paragraph three you were talking about, it doesn't really feel like any of those really fit. Technically, they're not in default because the government told them they don't say that.
However, as soon as that moratorium is lifted, they are in default.
Right.
But, you know, at that point, I'm going to have to say, oh, I have this tenant in place, but for the last 12 months, they've paid no rent. Yeah. So that's going to be one of those sticky issues that we're going to deal with when all of these moratoriums and forbearances go away and the market opens up with short sales and foreclosures and things like that. They're coming. Okay. Yeah. Been there, done that. It's been quite a while since we've been there, but I can see it coming again. This is the addendum for fixture leases. And the first paragraph asks you, what is it that you have leased? Is it solar panels, propane tanks, water softeners, security systems, or is there something else that you have leased? The buyer shall assume and the seller shall assign to the buyer the fixture lease at closing, except for the following. Okay, let's say I have propane tanks and a water softener and both are leased. The propane tank people say, oh no, We don't assume leases. We're coming to pick it up when you close. So I would have to say, except the following, the propane tank, because that lease is not going anywhere. They want their equipment back. That could happen. The buyer shall pay the first X amount of any cost necessary to assume or receive an assignment of the fixture lease. We saw that with security systems before. They're leased, and it'll be $100 to transfer to the new buyer. Okay, so the buyer would pay the first $100, and that would cover the transfer fee to take it out of the seller's name and put it into the buyer's name. And then the buyer would assume that lease. Okay. The buyer and the sellers agree to sign any documents required by the lessor in the fixture leases to assume or assign the fixture leases. I know when we sold one of our homes, in order to have the next buyer take over the lease on the security system, they had to sign a document that said that we were being absolved of all penalty or anything, and they were assuming. So there could be something like that the lease company wants them to sign in order to take over the lease. And you're basically just agreeing to sign that. So number 2, prior to closing, the seller will or will not remove the lease fixtures covered by the fixture lease that the seller does not assume. So if that propane tank is there and they are not assuming that portion of the lease, will the tank be removed? Well, since the propane company said, no, we won't lease to them, yes, it will, because I'm going to call the propane company and have them take it away. Then, delivery of the lease. Buyer has received a copy of all the fixture lease buyer has agreed to assume, or buyer has not received those copies. The seller shall provide a copy within 5 days after the effective date, and the buyer may terminate the contract within 7 days after the buyer receives. So if you don't give it to them within the 5 days, you've not committed to your timeline. It is possible that you are in default, but let's say on the 6th day you give it and the buyer accepts that from you. Now they have 7 days to decide if they want to go ahead with this contract or not. They could terminate based on the fixture lease addendum. Okay. At closing, there will be no liens or security interests against the leased fixtures which will not be satisfied out of the sales proceeds except for fixture lease covered by the fixture lease the buyer agrees to assume. In other words, the seller is going to pay up everything they owe before we close. And then it's all the buyer's problem. Okay, does that make sense? Any questions? Okay. Mm-hmm.
They did not write whatever repair in the second.
Mm.
So it was already on. And it was a big to do with day before closing.
Yeah.
Some packing security that is kind of specified to give remind people and we get closing.
It is kind of the point. You know, we've seen these issues over and over. We've had, you know, arguments, to put it politely, between buyers and sellers about these things. So now we have an addendum in place that's going to help us get through those and know who's going to assume what and who's going to pay for what. So I think it will help.
Is this a form that should be included in the document section on the listing? I don't know.
Only if you know that there are fixture leases. Because it's one of those conditional. If there are no fixture leases, you don't need it.
Right, but as a buyer's agent,
Mm-hmm.
then if this form is not on there, we can assume.
Mm. Oh, no.
That's why I said that.
Yeah,
Because, so this is a question that we need to be asked.
absolutely.
To be sure.
Yes.
That there's not before we get.
Now, when I go through the seller's disclosure, I could find out if there's something that's leased or not, because it would say on the seller's disclosure.
True.
So that's going to give me a lot of clues about things that I'm going to ask for. When I'm doing compliance, I'm going through your seller's disclosure. I don't really need to check it for anything but completeness, but it tells me, is there a MUD? Is there an HOA? Do I need a 1414 for special flood areas? So I go through it the same way you would if you were a buyer's agent, to see what extra forms you need beyond just the seller's disclosure. Okay.
Well, we're getting ready
to put in the house, if there's a security
Yeah.
out there, so.
Well, if I walk through a house and I see a water softener and a security system, and then I go to the seller's disclosure and I don't see that on there, that's gonna be a phone call. Hey, are those leased? Are those, owned? Why aren't they on the seller's disclosure? Yeah. Well, I would say if I know, if I have the seller and I know that there is something that's leased on the property, I'm gonna add it to MLS, yes. But if I'm the buyer's agent, I can't count on every seller's agent to do that kind of due diligence. I know. I was looking at one the other day and it said, see attachments, and there were no attachments. It's like, well, okay, so, yeah,
We're gonna see a lot of this with solar panels and home generators.
absolutely. Absolutely. Solar panels is a really big one. As a matter of fact, it's on here. But whole home generators, they didn't put that on there, but they left us a blank. So that's kind of the thing I think you'll see there. I'm having a hard time thinking of other things that could possibly be there. Those are the 5 big ones for me. Well, they list solar panels, propane tanks, water softeners, security systems, and I've already thought about whole home generators because of the freeze. And we're thinking of putting one in. So I have, I'd already thought of that one, could be leased. But, I mean, what other big things do you lease on your home? Generac, whole home systems, they do have a lease program.
They do.
Mm-hmm. Yeah, when I was looking them up, I found that out.
We're going to cut over switch route.
The what?
There's a cut over switch you can do on the electrical panel,
Uh-huh.
and then use a portable generator.
Oh, there you go.
It only costs about $3,000.
Yeah. Yeah. Sure.
I'm Brandon, so
Okay.
I wanted to be here and attend the meeting to learn, but honestly, I'm like, no, it's probably like, yeah. But my question is, so besides the contract, these are additional forms that have to be filled out now?
These are addendums
Addendum?
that would go with the contract if
So
that's
before-
the situation you have,
Oh, okay.
okay? On paragraph 22 of your contract is a list of all the different addenda you possibly could attach to a contract, okay? And if you have, like, this property is in an HOA association, a homeowners association, then in 22, we have to check the homeowners association addendum, and we have to attach it to the contract. It becomes a page in the contract. Okay,
these
so it
are
went from
added-
being, yes,
These addendums were added to that.
to that list. Okay, to cover new situations that we didn't have something to cover us for before. Okay, sure. Seemed like, oh, there was one other thing I wanted to tell you. If you will, look at this list here. Last week when I said, besides the 1 to 4, all of these documents are changing, I got a big gasp as if nobody had heard this before. So I just wanted to remind everybody, it's not just the 1 to 4. All of these contracts have changed. The unimproved property, the new home incomplete, the new home complete, the farm and ranch, and the condominium resale. Every one of them have been changed to the format that we just went through with the 1 to 4. Pretty much the exact same changes, okay? So that's why I've been going through the 1 to 4 and not going through each and every one of these, because they basically changed the exact same paragraphs, okay? The biggest change is our earnest and option money and where they go. And then adding in all these new leases. So those are our 2 biggest change on every one of these. But because of that, all of these are going to now have the date 11/10/2020, but these last 2 had to be changed. So we're going to take a look at that real quick. The only thing that changed is this right here, these words. Paragraph 23 now says paragraph 5, but because it changed, Your termination form is now dated 2/19/2021. And the other one that's dated 2/19/2021 is the short sale addendum. And again, the only thing that changed was paragraph 23, now is paragraph 25. There will be more forms that will be changing in the future because they're realizing, oh, it referred to paragraph 23. We need to change this form. And they've already talked about that in their last meeting. So there will be more. But as of right now, this is our list. All of the contracts we use all the time, except for the commercial, that's not changing. The addendum for the Property Owners Association, or what I call our HOA addendum, that's changed. Same date, 11/10/2020. And then these two, the notice of termination for the buyer and the short sale. And then these are the new forms that they added. Okay?
Did you talk about this change on the HOA form?
No, I'll pull it up for you real quick. I think this was just a paragraph as well. Yeah, I think it was. Trying to remember wherever it is. Yeah, they don't have them up anymore. I kept the contract red line versions, but I didn't keep this form's red line version. Was there? Red line versions. We'll see what changed. Hello. On the ranch, condominium, here we go. Deposit for reserves, that paragraph changed. A and D, they took out E and made it D. So deposit reserves, and what they're trying to remind you of with this one paragraph is that you need to include all of the fees, okay? Because people were just including transfer fees, and then there was a capitalization fee and it wasn't included, and there was a big fight about it. So now they're just trying to remind you all deposits, all fees, all reserves, all add here. So you should be seeing on your HOA forms that in some neighborhoods is going to be $1,500, not $250. Because the capitalization fee is $13 for that neighborhood, plus the transfer fee, that all should be there. Okay? So that's why they made that change. Any other questions? Not yet.